But there was a question that his father has expired recently. Father has 3 children, 1 son and 2 daughters, himself and 2 other sisters. And the 2 sisters poisoned the mind of the father. And when he died, he left the will, the property in cash or in kind, whatever it is, to the 2 sisters only. So what claim does he have? As far as the Islamic Sharia says, Allah has stipulated the shares of the children very clearly in Surah Nisa, chapter number 4, verse number 11 and 12, that as for the children, the son will get double the shares of the daughters. And the complete verse continues, which is not relevant to this issue. So according to Islamic Sharia, irrespective what you are saying is right or wrong, what your sisters are saying is right or wrong, irrespective whether the children are good or bad, the Islamic Sharia says that if a father dies, the son should get double the share of the daughters. So if there are 2 daughters and 1 son, totally there should be 4 shares made. Each of the daughter gets 1 share and the son gets 2 shares. Irrespective whether the son is a good Muslim or a bad Muslim. There's nothing like bad Muslim. Unless he leaves Islam. If he's outside the fold of Islam, then he may not be liable for the property. But as long as the fold of Islam, he may be a good son or a bad son. I'm not saying you're a bad son. But even if agreed that the son is very bad, he may be a drunkard, he may be ill-treating the father, whatever it is, but the shares have been stipulated. Allah says this is His guidance, irrespective of the son is good. Even if the son is good, the father cannot give more to the son, 1 son or the other son, or 1 daughter or the other daughter. The shares have been stipulated, no one can change. And Allah says in Surah Ma'idah, chapter number 5, verse number 106, 108, about the witnesses. And if suppose, on the deathbed, if the person gives a will or writes a statement against the Quran, the person or the witness has even a right to change it. So in this country, as far as Islamic Sharia is concerned, if the father has not made a will in India, because we follow Muslim personal law, it is followed according to the Sharia. Now, if a person makes a will, it can be disputed in the court of law. But if it is an Islamic country, you don't have to go to the court of law. Because it's very clear cut, irrespective of the son is good or bad, or the daughter is good or bad, the share that has been stipulated has to be given. In the Islamic ruling, if you ask me, you should get a share. 2 parts, half the property, whether in cash, kind, whatever it is. If you had a mother also, then the share would go partly to her. But since there is no mother and no other relatives, so you get half of the property, 1/4 to each of your sister. Now in India, if suppose your father made a will, and if you're living in India, or if you're living outside, you have to follow the rules of that. According to the Sharia, you should get. Then it becomes a dispute. You can go to the court of law and fight it out. And there are chances that you will win the case. But how well you fight it, that depends upon you.
In my village, the religious head, of course, he's not experienced as you are, because I think it's like being, seeing 2 consultants where there's a second opinion, and the second consultant may have more expertise in the fine nature of things. Now, he said since the certificates of, since they are held jointly in, one religious person said that as long as he has not given the cash and they have possession of the cash, it's exactly like you said, that the son has the rights. The other one said that no, since he has made a certificate of deposit and it's in their name, so you can't do anything. So there was a little confusion, and I'm impressed with your expertise. And obviously we'll appeal to the expert here.
The thing is that if he has put it in the name jointly, but the question comes here, that point to be noted is, that did your father give it as a gift to your sister? Point number 1. If he gave it as a gift, then the gift is given, whether right or wrong. But if he kept it in a joint name for security purpose as a nomination, it belongs to him. Even today, in the Indian law, if I buy a flat with my money, and if I keep joint name of my wife, when a dispute takes place, it comes back to me because the original source was mine. Fine? So here we have to realize that if he kept it in the joint name, only for convenience purpose, so that after he dies, someone else is there as a nominee, etc. So yet, the Islamic law applies, even in India. But if he gave it as a gift, mentioned in his balance sheet, if he has one, surely he'll be having, that he gave it as a gift to his daughter, that's your sister, then the issue may arise where a legal problem may come. But if he kept it in the joint name, one his name and one of his daughters, that's your sister, then it is yet clear that it belongs to him, it's only for convenience purpose.
Yeah, thank you so much. I think you put considerable light on the problem.